To kick us off, there are 5 types of intellectual property, 4 of which are governed from a legal perspective in terms of that there are acts that govern the type of intellectual property. It defines it, and all the rules of how each one works are in these acts. But then they are interlinked and they tend to work sort of together. Firstly, the first one is the benefits of, I forgot to tell you to make a list. Oh, finally, they're there. I'm so happy.
Yes, they're there.
Thank you. Okay, so this is just the brief, introduction of who we are and what we do. And these are the types of intellectual property. So I'll just be going through each one very shortly, just to give you like a basic of what they are. And then I think after that, then we can do questions. Hopefully, some of the questions will be answered through this talk. So first thing we need to understand is like, why bother with intellectual property? A lot of times we meet a lot of business owners who have been, in the business for quite a while, a couple of years, and then they want to now, protect something. And because they didn't do it right from the start, things can be quite messy. You find that maybe somebody else has, I don't know if people know the story of Bafana Bafana. Somebody, registered the word Bafana Bafana as a trademark, and Bafana Bafana continued. And when it was time to, I don't know why this person just decided to say, look, this is my trademark, and Bafana Bafana took forever to get it back. So we usually just advise people, clients, if you have an idea, if you're thinking about something, speak to like an attorney, get sort of somebody that you can talk to who can help you and start the process properly. But intellectual property is an intangible asset. So it's the same as a house. You'll find that now with the age of innovation, there is 90% of the companies on the S&P 500 have intellectual property as one of their largest assets. So there's a lot of move away from like brick and mortar. And I think that makes sense because of where we are technologically and the way that the world works. And intellectual property, it essentially gives you exclusive rights. So you have the right over this thing, whatever it is. So it could be your trademark, your patent, and we'll discuss what each one are. And because you are the owner of this or you are in control of it, then you are able to prevent people from using this asset of yours. And of course, it gives you a competitive advantage. If you have, for instance, like easily recognizable marks, for instance, like Nike, it's a competitive advantage. Everybody knows it, you trust it, and that's why intellectual property is important. It speaks to your reputation. And of course, monetization. So you can make money out of your IP. You can assign, which is a fancy way of saying you can sell. You can sell your intellectual property. You can license it out, which is known as rent. So if you have, think of a house, all of those things that you can do with a house, you can do with IP. So you can rent out your house, you can sell the house, you can franchise it, which means you teach somebody how to do it and then they pay you because now they're using your idea. You can open a branch somewhere else, you can get royalties from that, you can expand. So that is essentially what intellectual property is, and those are just the brief benefits of it all. Okay, to start off, I'm going to start with one of the most challenging ones, I think, for a lot of people, which are patents. So patents, essentially, they apply to innovations, and the Patents Act is quite strict about what an innovation is. So there's a whole list of, we have to test first whether this is a patentable idea. So most times we advise clients to say, look, if you've got this idea and it's working, oh, there's no slides. Thank you. Thank you, Benjamin.
No, so it's, I think they will take time to load because we can see them. So Benjamin, just give it a bit of time. I think Webinar Gem might be moody today. We don't know what's happening with it. So
Okay.
they will take a bit of time to load, especially I think if you're signing up now.
Oh, okay. Okay. So I can continue.
Yes.
So with patents, the big thing is that it's a technical solution to a problem, and it has to be new. So it must be innovative. It can't be something that anybody would sort of see that it can be done. And it has to be a working solution. So most of the time, this is the test that we run. Like, is this new? Is it a solution? And is it working? If it's still an idea form, you can use other kinds of the IP. So if it's not working yet, it could fall into, let's say, a design, or it could fall into copyright. But once it starts to work, then we can start to think of patentability. And the benefit here is that you have 20 years of exclusivity, which means that you've got a 20-year run. But the trade-off here is that with patents is that you are now putting this innovation of yours, your invention, you're putting it in the public domain, because you are essentially exchanging your secret, this innovation that you've come up with, you are exchanging it for the 20 years. So if you don't want to publish your idea, for instance, then that's a different form of IP. And then after the 20 years, then the patent is now open to the public, and then people can sort of use it, modify it, and all of that. And the point here is to encourage innovation, is to encourage development, because if, for instance, there was this bottle that was created and this person doesn't expose or tell the world how it's done, then you can't develop on this. So, for instance, the light bulb, it was patented years and years ago, but once it was open, now we've got these new innovations. There's LED, there's, solar powered, like all of that is because the inventor, they traded in their secret for the 20-year exclusive use and all of that. So you can prevent people from making your idea, from developing it, creating it, from using it to create something else during the 20 years, and then from selling and distributing this invention of yours without their permission. So like an example here is like with drugs, we see a lot of drug companies that will create a new formula for a new drug, and that formula is then patented. After 20 years, then that's when you start seeing things like generics. So generics are essentially just, it was patented at some point and now it's public, and there's a cheaper way of making the innovation, or there's a new way of using it and things like that. Next is trademarks. So the point and the aim of a trademark is to help to distinguish your product or service in the marketplace. So that's what we are protecting. We are protecting the brand, which is what makes you different, recognizable in the market. So things like your name of the business or the name of the product, your logo, your slogan, symbols, icons, all of that is protected in the trademarks, and those are governed by the Trademarks Act. The way the Act works is that it's split up the products and services into classes. So for instance, say I manufacture an insecticide. Because I'm in the manufacturing space, so I will probably register the trademark in a manufacturing class, which I think is class 1 or something like that. But if from manufacturing, I create a product that is like sprayable, so now I've moved from manufacturing into insecticide, or poison, or whatever the case may be. So now that's a different class as well. And then if I'm in pest control, because of that, then I'm going to register that trademark in the pest control services class. So those are how the classes work. It just helps to sort of identify where they are and how the mark is being used at the time. Trademarks are renewable every 10 years. So it means there's actually no limit. As long as you can keep on renewing after every 10 years, then you can keep your trademark forever. and they prevent confusion and, of course, brand dilution. So things like the Nike, you won't find Nike on water bottles, for instance. Now there's Nike water. They will come and give you a cease and desist and tell you to stop that, because now you are diluting what they are known for, which is sport and endurance and example would be like the word Sprite. The logo of Sprite, I think it's they've got that lemon, I think, and the slogan, something about thirst. They haven't used it in a long time, but those are all protected trademarks. And usually with application, we apply for all three separately so that they are easy to protect and easy to use. The next one is copyrights. So copyrights are quite interesting because in South Africa, you don't have to register them. So they are automatically protected as soon as the owner or the creator puts them in material form. So these would be your books, software, which is like the source code that is written down somewhere, paintings, films, all of those things are like your literary things that you can read, touch, and stuff. That is automatically protected. Interestingly, the defense or how you can defend your copyright is, first of all, you can do it from a civil point of view. So you can claim damages and things like that, but also you can lodge a criminal claim against the infringer. So with this, it also helps because it helps with somebody who makes a copy, first of all, but then somebody who can also change your copy. Just take it and then change it, and that's infringement of copyrights. It is a little bit more difficult to protect, but it's important to have that C in place. The next one is registered designs. This one is governed by the Designs Act. And this essentially protects the outward appearance of your product. So things like a bottle, a car, the shape that the car looks like, patterns, devices, the way that they look, that's, the smoothness and things like that. Things that are appealing to the eye. So the Act splits them into two. So they are beautiful aesthetic designs. So your handbags, that's why knockoffs are a bad thing, because you're infringing on these registered designs and things that look good to the eye. And then there are functional designs. For instance, in construction, you can, we've got clients who've designed a type of nail, that goes into a particular piece of steel, a type of DB board piece, and the way that it looks is essential to the way that it functions. So those are the two types of designs. So this is mainly for products. They are also, you can have them for quite a while. An interesting one is the Coke bottle. It's a registered design, so you can't have the shape of that bottle. It cannot be used or reproduced or copied. And then for the aesthetics, it lasts for 15 years and you have to renew. And then the functional is 10 years and you have to renew. And this one is quite interesting. It's quite technical. And the good thing is that it works hand in hand with patents most times, because sometimes you find that the person or the client has come to us and said, look, I want to patent this, but the product or the innovation fails the test. Then most times we then advise for registration of a registered design. And then the final one is please ignore my spelling for trade secrets. It's an invented word. So for trade secrets, it's confidential information. So, I think this one is quite popular, the Coca-Cola formula, the search engine algorithm. We can sort of come up with what we think it is, but it's not really well known at all. And this is the opposite of a patent, where the inventor or the owner of this is not going to open this up to the public. So it's only this way. Thank you, Saba. The only way of actually protecting this forever is if you keep the secret, which can have quite, it can be a little bit tricky. However, some companies and businesses have gotten it right. So here we use non-disclosure agreements, which can be quite technical because you sort of have to really name and specify exactly what it is that is the trade secret. And then you have to have a lot of measures in place to ensure that only certain people have access to the information, only certain people can use the information. So it's burdensome on the owner of the secret. And finally, that's all. Basic introduction of what all the trademark, what did I say, trademark, all the intellectual property elements are. But I hope that it could, help in terms of just sort of knowing or understanding what is and what is not. I think the most important thing is sort of just know that, like, at the beginning, I think that's the biggest thing for us. At the beginning of the process, at the beginning of thinking about this idea, before approaching people, make sure that you've got an attorney or somebody who can advise you on all of these aspects. And that's it. I'm open for questions.
Thanks so much, Rethabile, for that great intro. So a quick question, first one from my end that we have, that I have. So is a trade secret location specific? Can you say my trade secret is only in South Africa? Or once you log it for the different countries, you would need to resubmit it?
Oh, I think you're talking about trademarks. Yeah. So trademarks are geographic. So they are location specific. So when we are saying you're trademarking something, it's usually here in South Africa, and we apply for protection here in South Africa. If you are looking to go abroad, start selling in Africa, start selling in Europe, then we have to apply there. And the way that it works is the previously French colonized countries, they have one trademark office. So with that, it's one application, and then you've got cover, I think it's about, I can't remember how many countries it is there. So you can get covered in those countries. There are some that are independent. For instance, Namibia, you have to apply there to that office in particular. Botswana, you have to apply there to that office in particular. If you want to send your products to America, we have to apply there in America. So trademarks in particular are location limited. Same thing with patents as well. However, what we can do is you get a priority date. So if, let's say, I applied here in South Africa, but we've got like treaties. So if I've got a treaty in Germany, the countries have treaties. So my date here in South Africa will count as the application date there in Germany. So it sort of depends where you want to go, but we've made it, or rather the law has made it easier for us to apply and have the protection early on while you're still maybe developing the product or things like that.
All right. Yeah, my question was actually the trade secret.
Trade secrets. Remember, this is a secret.
So it's a secret. Let's suppose you have got someone, they signed the NDA in here in South Africa for your secret, and then they go to, say, Kenya for argument's sake and disclose that secret. Can you do anything about it?
Yes, you can, because remember, this person signed a contract. So they should not be disclosing the contract, the information to anyone anywhere.
All right.
Yes.
Okay.
Yes.
I hear you. So it's not location specific. All right. Thanks. So we've got a couple of questions that are on the Q&A. So the first one, it says, if a patent becomes public after 20 years, why is it we still don't know the recipe for Coca-Cola?
Oh, okay. Remember, Steve, the patent is registered. So you've now given the information to the patent office and they've now filed it. So the trade here is that I'm going to publish it in terms of giving it to the public domain, in terms of the patent office. After 20 years, it's open for others to look at. But the trick with Coca-Cola is that they did not patent their recipe. So it's literally just a secret that they are controlling. So remember I said it's quite burdensome on the owner of the secret. So they don't want anybody to ever know what's in there. And so we will never know as long as nobody, goes and snitches and spills the tea.
All right. The next one that we have is, how about when I mix existing technologies and then formulate a solution, like using AI with other technologies, then coming up with your own solution?
Interesting. The AI question is a big one now, because remember when we are training the AI, we are using information that is available in the public. But then what about copyright? Because remember, if I write anything, for instance, the contents of my website, that information there is copyrighted information. The textbooks that are on ebooks or whatever, they're still copyrighted. That's why we still have to pay for books and buy music. So with AI, and we are training AI on this information, sometimes you find that AI is actually infringing on copyrighted content. Legally, South Africa, or even the world, I think in general, is not yet up to scratch in terms of how to deal with AI. But I think there's a lot of scrutiny about where's this information coming from, because there might be infringements that are happening. So I think you're going to have like a proper AI strategy, like you scrutinize where this information comes from, what are the rights attached to it, who is the owner. All of that has to happen so that you can use this information in your new innovation.
All right, thank you. A patent law is universal. If I had my solution protected in SA, does that protection extend to other countries outside SA? I think this one you answered, it's that treaty one, right?
Yeah, but the interesting thing with patents is that we are able to do a one-off application in different countries. So when we do the test, for instance, or a patent search, we search globally to make sure that it's not, maybe there's a patent in the same sort of scope in Russia somewhere. So with patents, we advise for mainly international and national as well. It's best to just do that from the onset with patents. Whereas trademarks, it's your logo, your name. I think, it's difficult with that. But patents, we definitely recommend international patenting as well.
All right. So the next one is, what are the mechanisms in place to verify if your idea has not been patented elsewhere in the world beyond your country's jurisdiction? Do you have anything to add on to what you just said now? Yeah.
No, it's definitely that international search that we do.
All right. Then the next one that we have is, what are the costs associated with these processes, if you are able to share?
Oh, it's different for each one. Okay, so with trademarks have like a set costing that we do, because the process is sort of step 1, step 2, step 3, and we are more or less able to gauge how much they can be, right? The cost there. With patents, there's a couple of steps that happen, and there's like provisional patents, and then we can sort of finalize. So all of that changes according to the complexity as well. Copyright, remember, there isn't a whole lot that can be done in terms of applying, but for protection, it's a litigation process. And what's the other one? The registered designs is also, it's quite a lengthy process as well. But we do have fees that we discuss, with the client. We let you know how much it's going to cost, and then we can, sort of take it from there in sort of like a step-by-step process. And yeah, the non-disclosure is also quite technical, so that also has its own costs.
All right, cool. So I've got other questions before I come back to the ones that are there. So the one that I have here is, so if there's an entrepreneur or an innovator who has decided to design something, which type of IP protection do they need to look at, which is affordable? Or does it go by case, or how does it work?
Yeah, it definitely goes case by case. Remember, I've heard a lot of people who are saying, I want to patent my logo, only to find like, oh, you're not talking about patent, you're talking about a trademark. So, and then sometimes there's a software. Somebody's talking about, no, I've got a software, I'm an app developer, but now we know that software is copyright protected. So most times it's best to just come and then we discuss so that you can sort of understand what it is that you're dealing with and how we can protect it. So you can't decide that, you know what, design is too expensive, I'm going to go into trademarking, but then we are talking about a perfume bottle or you know, something like that. So most times it's like, okay, come, you can bring your stuff, we'll taste the food, we'll look at it, and then we still we protect it according to what they need.
All right. So the other one that I have is, what are the steps that someone must do before they publicly share or pitch their ideas to investors or partners? Do they need to protect it, or they'll need to do it afterwards? And the reason why the person was asking this question is because the view is that the other times what they go with might change because of the feedback that they've received from investors or partners.
What we usually do, interestingly, is with patents, remember the idea has to be new. That's what the act requires. And you can kill novelty by literally just telling somebody else. So if, especially with scientists, people who have made this brilliant discovery, they'll go on like a talk like this and they'll go and say, no, we've invented a this and this and this, and right there, the novelty is killed and you can't register that anymore. So in order to protect, you have to really honestly be very, very strategic about who you speak to and what information you tell them. What we usually do is, before you start going to disclose anything, let's first put the IP in place. Let's first protect the IP. So if you are inventing a charger, for instance, before you go talking to investors about production and this and this and this, make sure you've got the patent, it's in your name, and it's done. So by the time you go and speak to investors, it belongs to you. Because sometimes you find that you're going to pitch an idea and they have the money, you know, they understand, they'll ask you like technical questions, you'll give them everything that has to do, and then they just go and make it themselves. So most times start off by first just putting the IP in place first, and then you can approach these investors and things like that. So the invention process or the idea process is twofold. You know, it's first this invention part, which needs like its own protection. And then it's the business part, which is now your agreements, your contracts, your trades, like all of that, your monies, all those things are separate from the invention part of the process.
All right. I think while you are there, you can probably answer two of Mzwandile's questions. So one of it says some countries don't have patenting bodies. What do we do? Then the second one is I've done NDAs and still got tricked into presenting my idea. They may not have taken it, but somehow implemented it within their solution. How do we deal with greedy cats within the corporate space?
Yeah, I understand the greedy cats. That's why we say patent first, protect first, before you go pitching your idea. Because with the NDA, you're literally just saying, like, once you've got the IP, say you've got this special machine and it's going to revolutionize the way we make calculators. And that new invention, the IP is in your name. Then now you're just going to investors to say, look, I've got this invention. It works. Are you guys buying or not? Or are you guys going to invest into 35 shares or whatever the case may be? So now you've moved out of that into the business side. So yeah, a lot of people get tricked because they start to divulge information before they've done the IP side of things. So the greedy cats, you need to protect yourself first and foremost.
All right. And then the countries where there's no patenting bodies, does it mean that it's free for all?
That is very strange because all countries have a patenting office. Maybe they're not functional, but every single country has to have some sort of patenting body. They do, but some are difficult. I'm not going to lie, it takes quite a while. However, each one must have, or they are part of like an organization, for instance, like I spoke about, like the North Americans, the European bodies, they all have something. I think maybe just research and maybe just speaking to us and we can, find out which country it is and whether you're talking about patents or something else.
All right. Another one from Steve. If there is a patent in another country, will you then continue to register the same idea in your country, or you have to rethink your idea?
You have to rethink.
Okay. Nice and short. All right. So my next question as well is that when we're preparing for this session, I just Googled and searched, and I noticed that in Silicon Valley, there is over 20,000 patents that get issued. Like in 2024, there was over 23,000 patents that got issued, while in South Africa, there was only 13,000 as a whole country. And here we're just talking about one part in US, San Francisco. Mm-hmm. So what do you think is the cause for it? Is it the knowledge in innovators or the cost? What exactly is it that's leading to here people in South Africa not registering enough patents compared to what's being done overseas?
I really think it's information, hey? A lot of us also, we get so excited to tell somebody our big idea without really understanding what we're doing, firstly. And secondly, IP is not very well known. It's not well understood also. I meet a lot of people who think it's just something at the end, let me just do the CIPC registration. If I've got the MOI, I've registered on CIPC, I've got the company number, I'm ready to go. And we don't really have a lot of information about what is this, what are the benefits, what is the weight or the value of my creation. So I think information is a big one. I think information is a very, very big one. Because over there, remember, they are allowed, I think when you are around innovators, the information is always with you. That's why in San Francisco, because it's innovators, they know a lot. They are mentoring each other. They are there's a lot of knowledge that's being passed around all the time. Whereas in Africa and South Africa in general, there isn't a lot of information out there. And yeah, we tend to just we're hustling, I'm doing this on my own, and we don't have the information. And we obviously, and I think honestly, I've heard this so many times, what you said before this, I'm so excited for this talk, but I hope you don't charge us.
Yes, I was worried, Kelvin. I was worried that we might get an invoice from Rethabile.
You see, and that would have prevented you from talking to me and from us, being in this talk. So a lot of people are afraid to even just ask, yeah. And let's open up the industry, so to speak.
Thank you so much, Rethabile, for coming along. And thank you so much, Team IITPSA members and non-members as well.